Good afternoon, I'm Taylor Giusti with MLF Legal, and I'm here to talk about some of the new developments in workers' compensation law. Most of what I'll be talking about covers 2017, although there's a couple cases from 2018 that I'll also be discussing today. To begin with, I'll be discussing a case about 90-day finality rule. This is APD 172534. This case concerns the delivery of a certification by both mail and email. What makes this case significant is there's not a whole lot of cases as far as email or electronic delivery as far as 90-day rule is concerned. What happened in this case was the carrier had delivered it by email and did not. He had assumed that, well, the email didn't get kicked back, so the carrier or the claimant must have received that email. The court ruled that they equated that similar to sending it by unverifiable means to someone's house. Just because you have the home address correct and the letter doesn't get delivered, doesn't mean it was delivered by verifiable means. In the same way, if you just send an email, that's the same as just knowing what the correct address is, but you have no way of verifying whether they received it or read it. Therefore, the court suggested that maybe something such as like a red receipt or some other sort of program would be necessary in this case. In the end, the claimant did not prevail. They also sent it by mail by verifiable means. However, I've encountered cases where they have not mailed it by verifiable means, and they might rely on this assumption that just by sending an email to the correct address is more than enough. This case shows that no, you have to have more than just an email in order to show that it was delivered by verifiable means. Because the carrier might try to play on this assumption, it's important to keep this case in mind if you're ever dealing with a email as far as the 90-day rule is concerned. The most significant case that I encountered as far as 2017 goes is APD 172459. This is a SIBS case, and the case states that if the carrier states an incorrect number of required work searches under DWIT 52 and the claimant relies on this information, then that number of work searches is ruled to be sufficient for qualifying for SIBS. If you've ever dealt with SIBS, you realize how strongly the rules are enforced, and there's not a whole lot of leeway as far as SIBS are concerned. Therefore, if there's any sort of exception or way around a rule, it's important to take notice of that. The only exceptions as far as good cause and as far as carriers providing inaccurate information are the 52s. The only case I was able to find in my research as far as good cause goes is a case in 2012, APD 120154, where the claimant was robbed by an assailant using a baseball bat and was in the hospital for 3 weeks. Because the claimant was in the hospital for 3 weeks, the court ruled that they had good cause for not being able to perform the required number of work searches. Therefore, unless you're in the hospital after being beaten with a baseball bat, you're likely not going to prevail on good cause. Therefore, this case is an important one to take under consideration. The other case where an inaccurate information was considered is APD 010617, which is also referenced in this case, which also makes this case important because that case was decided under the old SIBS rule. The court rules that this case is also applicable in this case because the claimant relied on incorrect information sent by the carrier, and it would be unjust to let the carrier reap the benefit of their own mistake. Therefore, in that case, the case that the court references could be seen to be incorporated into the current SIBS law, in that if the carrier provides the inaccurate dates or the inaccurate time period or qualifying period, that those would be able to give the claimant an excuse for not doing the required work searches during that time period. Finally, this case is also significant because it cuts against a major ruling as far as good cause goes from 2014, APD 142069, which states that ignorance of the law and ignorance of the rules is not an excuse and not a basis for good cause. Here in this case, the claimant was made aware at some point that he needed 7 work searches instead of 5 work searches. However, the claimant relied on the information given by the carrier and only did the 5 work searches. Therefore, with this case seems to give an opportunity, even if the claimant relies, even if the claimant knows that there is further work searches that are required, they can still rely on this 52. While it'd be a bad idea to tell a claimant to solely rely on what the carrier says on work search numbers, this case provides an exception in case they do. Also, as I stated before, because there's so few exceptions to the work search requirement, each one is important. As far as a trend goes, while this is only one case, this case could signal a trend that the appeals panel is starting to take a softer stance as far as SIPS requirements, because of the fact that this case does consider an exception to SIPS and also incorporates a case under the old SIPS law. While that's not guaranteed, it could be a sign of further cases to come. The other case I'm going to discuss is a compensability case in the form of an occupational illness. What struck me as significant about this case is if you read the case and was unaware of the issue being litigated, you might think that it's an extent case. The court goes at length discussing whether the opinions by doctors were sufficient as far as what was required in this case. Under the facts of this case, a claimant was injured when he was exposed to a chemical compound and suffered various issues as far as breathing, as far as issues with his nose and his mouth. And what the court stated was that for toxic exposure cases, you have to have a specific substance and how the exposure to the substance caused those symptoms. Another case that I encountered from 2018 that mimics this, in this case is APD 170329. The other case I encountered that was very similar to this is from 2018, which is APD 172582, which is another compensability case involving similar facts that states reactive airway disease from chemical exposure cannot be found to be compensable without a determination of what chemical the claimant was exposed to. Once again, this case is important because just for compensability and disability, just to get your foot in the door, you're going to need expert testimony. You're going to need a doctor to explain why that chemical caused the issue the claimant is suffering from. Whereas normally in a compensability claim, all you need is just damage or harm. This seems to make toxic exposure cases a little bit more of a heavier burden for the claimant. Further, it's something to keep in mind for intake purposes, because when you intake a client, you need to have the client be able to either say what chemical or compound they're exposed to, or have some way of discovering what chemical or compound you're exposed to. Reading these two cases together, if you do not have that chemical, you're not going to prevail. Therefore, this case is important for both intake purposes and for practice purposes, keeping in mind that for practice purposes, if you do not keep in mind that you're going to need expert testimony, you will not prevail. Finally, similar to this, another compensability work hazard case is APD 171882. This is a case involving Lyme disease where a claimant was bitten by a tick. The claimant worked as a animal control specialist and was exposed to different animals. The claimant then was later diagnosed with Lyme disease. This is another sort similar to what you might call a toxic exposure case or occupational disease that has an incredibly high burden that is put on the claimant. Because the claimant was bit by a tick, the type of tick must be, or species of tick must be known. The tick must be tested in order to find out if that carries Lyme disease. And then third, the doctor must be able to say that because that tick bit the claimant, that caused Lyme disease. Once again, this is an important case because it is only compensability, however, it puts a very high burden on the claimant to be able to prove all three of those facts. Therefore, that's another thing to take into consideration both at the intake stage and the litigation stage of facts that need to be known. Finally, the final SIPS case was similar to the one I originally discussed, was a APD 170747, where the appeals panel states that, the appeals panel does not state that the claimant had good cause for failing to do all the required work searches, the appeals panel left open the possibility that there could be good cause. In most cases, the APD was, even though it would seem to be a fact issue, in most cases, the APD outright states that good cause was not there. However, this is another case that moves toward that trend that states that there may be good cause for missing the work searches. In that case, the carrier made a second 52 with the correct date for the qualifying period. However, the reason this case was decided differently to the original SIBS case I discussed was that there had not been a determination on first quarter SIBS. Therefore, if there's not a determination on first quarter SIBS, the good cause argument might be your better route. Whereas if you've already got a determination on first quarter SIBS, the reliance on incorrect information might be your better route. That concludes the cases that I found in 2017, the first part of our 2018.